เคสวัสดีค่ะ
สวัสดีค่ะ
สวัสดีค่ะ Hi guys okay Hi guys good evening welcome to today talk on TDPK Talk Startup Story episode 10 Our topic today is legal unfold overcome key legal mistake for startup that's what we're gonna do today and my name is John I'm a partner at a law firm, a Bangkok-based law firm called Native and Partners. I'm here today with two of my associates, Nong Kieo and Nong Ploy.
Hi guys.
Okay, we will be hosting a session today. Today the session will be a 60-minute session. So I will divide our session into three parts. The first one is the introduction. The second part is we're going to talk about the topic on what's a key legal mistake that startups should avoid. And the last part is going to be Q&A. We have got some Q&A from you guys already. We will try to address it during our talk, or if we cannot, we will address it at the end of the talk during the Q&A session. We try. That's what we try to do. So if you have any comments, you can talk to us through the chat log. You can talk to us through the chat log under the live. So we'll be monitoring and we'll try to attend to all your questions. So let's start. How are you? I hope you guys are okay during the Songkran holiday. Actually, this live we intend this session we intended to do it on April the 7th, I think initially as an offline event, but due to the COVID situation, so we here as live, and all the three speakers here, me, Gil, and Ploy, are self-quarantine as our home, trying to stop the spreading of COVID, and I hope you guys are staying safe and well. So let's start our session. Okay, with the can I get the slide, please? Thank you. Okay. Today's topic: legal unfold, overcome key legal mistake for startup. I'm not sure. I understand that there might be some of the Thai speaker who might have seen a bit of my talk in February with True Digital Park. That's the Thai version, and here today is an English version of the same talk. As the topic says, it's legal unfold. We during this talk we'll try to tell you as a lawyer, based on our experience, we will try to tell you about how what difficulties on the legal perspective that we have seen our clients been dealing with, and once that you know about it, I think it will help you to overcome those mistakes. Okay, just a short introductory to our firm. We are Native and Partners, legal counsel. We are a Bangkok-based law firm. We've been established for about 16 years. We have 5 partners and about 24 or 25 associates, but we're not dealing with all the the full spectrums of the law. We are focusing on 3 main practices, which are M&A, merger and acquisitions, capital markets, and banking finance. Like in startup world, it's also when it's you can relate it to M&A and capital markets as well. Like when you do a fundraising, either it's a seed round, Series A, Series B, or even if like when you success and you do the IPO. So that's what we deal with. So in our experience, since we started the firm, we have been focusing on the M&A practice and capital market practice for normal company. But given that the startup ecosystem in Thailand has been growing up a lot, so we're trying to shift our practices and to help to build a startup ecosystem. So during the past like 3 or 4 years, I've been working closely with a few startups. I wouldn't say like a lot, but yeah, we've been dealing with significant numbers of startups that we have assist, and we understand their difficulties and help them through the fundraising. Like some of them are even seed rounds. Or angel rounds, or even the exit between the founders when they have disagreement, or we do Series A's and Series B's for some of the startup. We represent both side of the deal. In some deals, we assist startup. We are startup counsel on the fundraising, and some deal we represent the investor. So we kind of understand like the requirement from both sides. So we just so you know, if you need our help, just shout out. You can go through our website www.natipartners.com, or it's even more easier because we are collaborating with True Digital Park on the one-stop service. You can go through them, go sign up just in the Google form. They will send us your queries. We have an appointment to speak, and we will help you the best we can. Okay, I have already covered in the outline, so the introductory has gone. Okay, yeah, like I mentioned, I hope that this session will help you deal with your capital structure, fundraising, and other legal matters that may concern you during the day-to-day operation. So if you ask me, what are key challenges when advising startup? I would say that part of it, as I already mentioned, it's similar to a normal M&A transaction, but in a way, it's also have their uniqueness of a startup. Because like in normal business, if two partners want to do a joint venture in a company, the company is already there. They're doing a business operation, so they have either a new strategic investor investing in the company. But startup is like that. So the founder founded the company. They want to raise fund to expand the company. But the key is the word expansion. Expansion is really an important term for startup because it's a different angle from normal company. Because startup is a fast grower. As I say, advisors have to think ahead as startup are fast mover. So you start from seed round, maybe you start from nothing, just after idea stage, you're trying to do the prototype, you're trying to launch a product, you're trying to expand the market, you're trying to build something, like build more data, like doing more of the technology, improve your platform. So it's a fast grower. So like in 3 years, maybe you raise 2 rounds. In 5 years, you raise 4 rounds. So it's then therefore it's the second sentence here that startup business is not a constant picture. Moving back to normal business, you just have to expand the business, and then you try to grow like steady growth. But in the startup world, everyone want to jump start. So you have to hit the point and you have to go boom, you'll be a unicorn. So that's why when lawyer helping startups with their fundraising, when you think about their share subscriptions or the shareholders agreement between the founders and the investor, like in each round, you have to think ahead, like whatever you're giving out, maybe like in a year they will raise another round. So you have to think of the benefits of like as a founder, you have to think of the benefits of yourself. And you, like when you're doing the cap table, I'm sure everyone is very familiar with cap table. You have to think about the power that you're giving out to the investor, and you and what you retains to be yours. Okay. Now, I do with our experience. we're trying to, select the top 6 legal mistakes that you should avoid. If you know it would help you with your operation from legal perspective. Definitely, there's a lot of other perspective like accounting, business-wise, or technology that you have to be aware with. I just hope that this session, our 60-minute session here today, will help you more or less to know. Okay. So 6 key legal mistakes for startup. The first one is a founders agreement, then regulatory requirement, benefits, incentive, corporate structure, intellectual properties, and personal data protection. That's the hit one, Okay, I will go into 2 details of each of the subsections. First one is a founders agreement. Gil Apply, can you tell me what's the founders agreement? So,
Okay.
because I cannot do an interactive session with you guys as a participant to this live. So I will be talking to my associates. They will be that they are founders of the startup and yeah, let's see. At least I have someone to talk to here.
Okay. Generally, I think it's kind of like a prenuptial agreement. So when founders enter into something they agree on and want to create a business together, so they want to set out their rights and their duties like clearly. So they put into an agreement in writing.
Yeah, exactly. Exactly. That's the thing. Founders agreement is agreement between the founders of the startup of the company. So normally I see like there when you do the startup, you're not alone. It's not like one day you wake up off your bed and then you do the coding yourself, you do the business yourself, you do the everything yourself. It's what I have seen is not like that. So it may be a couple of friends, like people knowing each other doing the startup together. So like Gil said, it's like a prenuptial agreement. So it having a founders agreement doesn't mean that you don't trust each other. So it gives a benefit that first of all you're understanding the role and responsibilities of each partner. Then you set a clear goal and commitment, and you also have a backup plan. So what is it? Like you said, like Gil said, it's a prenuptial agreement. Prenuptial agreement is agreement like before a couple, a spouse getting married. So what you entering into and you what's you gonna deal with it if it doesn't work. So it's work the same way. Understanding the role, the first benefit of founders agreement is everybody is gonna understand your role, who's doing what, and what and the numbers of shares that you can getting or the portion of shares. And then you have a clear goal. And then you have a clear goal on what you have to do, and you record it. Like, if I'm gonna start a startup business with Gil and Ploy, so I'll be the CEO, Gil may be CMO, and Ploy may be CTO. So we know the clear rule and on who's gonna manage what and stuff. And then the third one, the backup plan. Backup plan is the most important. I think personally for me, I think it is the most important part in the founders agreement, because you will know that if there's a disagreement, a major disagreement, what you're gonna do, who has the most say. Because if it's a 50-50, it's just me and Gil, for example. If we have a 50-50 share, so it creates something called deadlock. And when we create a deadlock is created, it is hard for the company to move ahead, move forward, because I want this way, Gil want this way, so we cannot, and it's impossible for us to agree on. So at least we have some mechanism to take care of that. we'll go into detail in the next slide. So, okay, founders agreement. I'm sure everybody have heard of that, and I think more than 80% of the startup probably have one. But is your founders agreement good enough? Have enough content, sufficient content to actually help you when there's a problem? So because it's easy, anyone can do and can, like this day, anyone can just go. You can Google and you see a lot of documents say it's founders agreement. You can get an example. You can like edit this and that, and then here we go, your founders agreement. But will it actually works under Thai law? Because if you Google it, you may get like a founders agreement under the US law or UK law or even Japanese law. But will the founders agreement that actually the document that was drafted under the foreign country's law actually works under Thai law? Definitely some part will be working, because it's just a business part, commercial part that people you record like on role and responsibility. Definitely it's working. But what I want to give you an example is that there are some agreement that might not be working, because we are Thai company. There's a different laws that regulating the contract. So what a good founders agreement should have? The first one is you should have the clause that setting out the roles and responsibilities of each founders. That's easy. Then shareholding. Then the shareholding. On the shareholding part, so you have to know who held which amount of share. It's easy when you do the founders agreement. If like three of us, Jankyo employ, so we have 1/3, like 33.33% of shares in the company. But what if we raise fund? What's gonna happen to our share? What does it call? Start with a D, Ploy. If we raise fund, what happens to our share?
So it'll get diluted. So you have to pretty much either subscribe to your proportions or you'll get diluted.
Yeah, that's right. So, okay, this is not scripted. She was surprised to get questions like that. Yeah, but she passed. She passed its test.
Feel like I'm in a test.
All right, it's a dilution, definitely. So right now, when we start a company, all of the shares from three of us constitute 100% of shares. But if you raise fund, definitely this 100% will be diluted. If you raise fund for another 20%, our 100% will turn to be 80%. So I will not be holding 1/3 of the company anymore. I might be enough. Okay, if to put it easier, we raise fund 25%. So if we raise fund 25%, the dilution will be 25%. Our 100% will turn into 75%. So I will not be holding 33.33% of the company, but I will only hold 25% of the company. So in the founders agreement, as Ploy mentioned, sorry, I have to go back a little bit. Under Thai law, so you cannot a general principle, you cannot place shares to new shareholders. You have to offer the shares to all existing shareholder on a pro rata basis, unless it's for the extension of the SME and startup special law. That's a very technical details. We're not going to it today. But if you have any questions, you can contact us, like send us an email or something. So that's why we have to agree between the partner that when upon fundraising, if needed, everybody, if agreed in the term sheets or whatever, all the partner has to agree to waive their right to subscribe new share. So otherwise, if I don't agree to waive my share, Ploy don't agree to waive my share, and we have to increase 25% to get the money into the company, to get a capital injection from from the investor. So Gil will be end up like diluting her own share. So I will still be, you know, I will still be holding the same amount of my share, but Gil portion of share may be less than 10%. So that's not fair for her, and we do not want that to happen. So that's why we have to agree on how to deal with our shareholding upon fundraising. Another thing is about the vesting of shares. So for founders, actually, like for the original founder, I don't see a lot of vesting conditions in the founders agreement. But for example, if you start a company to a certain stage and you want a new partner to contribute and help you more with the company, and they are not only employee, but you want them to be like co-founder. So that's where you have to think about how you want to deal with how you want to give their share. Is there any like KPI, key performance indicator, to give away the share to them? The next one is remuneration and benefits. Definitely, we are not non-profit organization startup. We want money, so that's why we're building a company. So we are driving for profit. So I know like in the early stage, so most of the company may be like running on loss and burning the capital just for so that we are ready to make profit. During that stage, that shouldn't be any problem. But if the company actually flies, the business actually good, so we have to talk about remunerations and benefits. So we will get bonus, we will get special remuneration or special awards for your performance in the past. That's something that you have to agree. On the management of the company, definitely everybody has their own title. I'm the CEO, Gil is the CMO, Ploy is the CTO. But who actually has the say in the company if something wrong, something happens, and if there's a tie vote, that's there is no one answer fits all for this kind of questions. It's actually due to the facts on various circumstance in the company. But I just want to highlight it out so you know what you should be looking for. Then is a target and expectation. That also links to the remuneration and benefit, and also linked to termination and exit strategy. In the founders agreement, definitely when you start a company, you don't know. You're not sure. You wouldn't know if you can actually work together. You wouldn't know whether or not your partner will perform the way you expected. Not that they're not good, but it's just sometimes your chemistry is not right. It's like you and your boyfriend or girlfriend. You're dating. It's look good. After 2 years, it might not be good anymore. So you have to have an expectation. You have your own expectation, but this is just what you're writing down your expectation. And if you don't, if the expectation is not met, so there should be an exit strategy. Talking about exit strategy, this is I think it's a very important, even most important part of it's like a most important part of the agreement. So like when the relationship between the founder doesn't work, what would you do? So there's a lot of elements that you can do. First is the right of first refusal, or RFR. RFR is it's a share transfer restriction. Normally, if you are in the shareholders agreement, the founders agreement is also kind of shareholders agreement. You have to have a restriction because you don't want. For me, I don't want Gil or Ploy to just easily transfer their shares to anyone I don't know, because I'm in this together with them because I want them to be my partners. So the restriction is that most of the time, the most common restriction is that if Gil want to exit, she has to offer the share to me first, to me employee. So basically, you have to offer your shares to other shareholders first, and other shareholders have right to subscribe. If they don't subscribe, you can then sell to the third party. But for for the partners, so I'm not sure. Um, I might not. I might not want other partners, so we can twist it around a little bit. Like, Ploy might not have to say to select the partner, but it's Gil and me who will have to find a third party purchaser who I want to continue to working with to replace Ploy. So Ploy have to sell that to them. There's more details on it, like the price. What should be the price? Should we have independent appraiser to do the valuation on the price? So that's one of the thing. The other item in the exit strategy package is the call or put option. What's a call or put option? Call option is we will set an event that is a call option event or put option event. Call option is if any specific events happen, you can actually call the share. So Gil is so I'm always look like a bad guy. So let's see. I'll be the one leaving, and Gil will be the one calling my share. So I want whatever happen. It's linked to the target and expectation. If me as a CEO cannot operate a company, cannot supervise the company, run the company to the expectation that the other two partners expected, so I might have triggered a call event. So let's say the company should have made like 10 million baht profit. The company should have made the 10 million baht profit by this month, but I still fail. I only can only make like 5 million baht, or I'm still operating at loss. So it's all my fault. What should they do? So they want to replace me with a new CEO. So that's where the call option come from. I trigger the call event, what they call call event, and then they can set up and the sorry, I trigger the call event, and then I trigger the call event, and then we already set the price to call my share back, and then they call my share and then I will be obliged to actually pay, actually sell my share to them, and it's options of Ploy and Gil whether or not they're going to keep my share or they want to sell my share to other people. So that's what it does. The other two is non-compete and non-disclosure. Non-compete is very important because founders are important people to the company. We know a lot of proprietary information, trade secrets, right? So basically, say Ploy is a CTO. Ploy is leaving. Ploy has all the knowledge about our application. So Ploy, if Ploy going to exit, I would require her to sign a non-competition. Non-competition is that she will not be working for our competitors, because the most important things of startup is their secret. Actually, most important things of all the company is that trade secret. So Ploy shouldn't be working for our competitors unless I waive the rights. And the other thing is the non-disclosure. Ploy should not disclose any confidential information of our company to anyone, not just our competitors, but to anyone. So remember these two clauses, non-competition and non-disclosure. That's what you should be looking and putting into your founders agreement. Okay, sorry, I was on the first topic super long because because I think founders agreement is really important. It's the first agreement that you will be making, and if you don't have a good founders agreement, when the VC come in, they look into your founders agreement and they will require you again that, okay, please revise your founders agreement to be up to our standards. That I have seen is a lot of cases that founders agreement has to be terminated and you do it again. So it's better to do the proper one in the beginning, so to avoid the negotiation at the later stage. The earlier you do, the easier It will be. All right. On the regulatory requirement, this is gonna be another long one. But okay, I'll try to separate the time nicely. What's why regulatory requirement is important? Because the founder needs, I'll read from the slide. The founder needs to understand the regulatory framework governing its business to ensure smooth operation and compliance with law. What I do not want to see my clients dealing with is that they have a business so good, like the business is going to fly, but then they just realize they've, they've been operating against the law. They didn't comply with the law, so they have to change their business structure, and that's cost a lot because um, it's a momentum that will be lost if you have to cease your business operation just because you're not complying with law and you have to redo it again. So I would say I would separate the importance of the regulatory requirement into three big stage. The biggest one is you know um, if you are operating. First of all, I assume that most of you guys listening here are foreign speaker, aka a foreigner. So Thailand has a really strict foreign investment law that any service business, most 90% of the service business will be subject to the foreign indirect investment law. So basically, whatever, if the company even it's incorporated in Thailand, it will be regarded as a foreign majority owned company if a foreigner holds more than 50% of shares in the company. And with that being said, being a foreign majority owned company you will be restricted to conduct a lot of you'll be restricted to conduct a lot of business. You say if you are doing the platform and stuff, it will be considered a service business and you will be prohibited to do unless you fall under the certain benefit and incentive that I will be explaining in the next slide. So just that first. On the big picture, we would categorize some of the business as a highly regulated business. Say if you are asset management company, you want to do intelligent asset management app. You have this algorithm that would help people do the investment and stuff. You will have to comply and you have to register and apply for the security brokerage, security dealing, and asset management license. So you have to know what's the regulatory framework of the business that you're doing. So, for example, other one is the P2P lending. P2P lending requires approval from the Bank of Thailand before you go into conduct. So that's why you will have to know it. And apart from that, not only knowing that what you're gonna have, it's also links to the how you're gonna structure the capitals of your company. Because in some license, it requires that you have a minimum capital register. It's required that you have a minimum capital register at maybe in some company it's 100 million. In some type of business it's just like 5 million or 10 million. So you have to look at it closely to make sure you complied with it. On the smaller picture, maybe you already comply with the key requirements. Say P2P, if we are doing the P2P application, you already got your approval from the BOT, Bank of Thailand, to do this. But there are some elements in the app, in your workflow. Say you giving out the loan, P2P, the interest rate is capped at 15% per annum. But if you don't know this, you will and you charge your platform charge at 18% per annum. So that's expose you to additional risk. Or if you are a company that helps people that helps connect people, and it's a platform like, for example, you are the service um, housekeeping service platform, and you don't have to comply to any regulations, but then there's a features in your app that you have a payment gateway, you have to use the wallet, and you don't have that unless you unless you um, unless you engage the wallet operator. If you do it yourself, so you have to know that there's another approval that you have to apply for. So there's a tiny element that you have to know how to comply, and it's not easy, because in some of the time, you only because if you are fintech, you only contact Bank of Thailand, but that's not the whole the only regulator that you have to do. You have to go through details of all your workflows and understand like which features required to be compliant with Thai law. So and some of the features, like when you do the fundraising, if you are Thai company and do the fundraising with Thai CVC or Thai VC, they are familiar with how Thai people how Thailand operate. Some minor failure to comply with the law. Say, for example, if you're selling stuff online and you do not have the what does it say? The e-commerce registration. If you didn't register for the e-commerce registration, you can just go and register, and that will I from what I understand, the penalty is not that high, so the investor can weigh the risk of the business opportunity that they are going to have and invest in for the growth of the company. But then if it were international CVC or international VC, they might see it as a much as a high risk red flag, and they might just pull out because of that. So it's better to comply with it before you do the fundraising, or before the investor conduct the due diligence in your company and turn out that you have this small difficulties that you have to handle. But the other thing is, once that the mistake is found, it's a way on how you communicate with them. I found that it's really important that you have to communicate it right to the investor on what's the risks and what's the upside of your company that you're going to your company growth. Yeah, Paul, you have any questions on this regulatory requirement?
No.
No. Okay. So okay, we're moving on to. Please also monitor.
Just a second, I think she just lost her connection. She should be back shortly.
Hello.
Now she's back.
Sorry, I don't know what happened. Okay, something is wrong with my. Okay. Okay, we're good. I'm sorry. I'm really sorry. Can get a slide back, please? Thank you. Okay, so this is the difficulties of what you are a low tech girl and you're trying to do live video from your home alone. Okay, thank you. The next one is benefit and incentives. I'm sure everyone. I'm sure everyone is familiar with the board of investment. Board of investment is the authority in the government authority in Thailand that helps promote the business, help promote the business. And one of they also have a section that is particularly interested startup, because most of the startup involved digital platform. They have this section for digital innovation, which require the minimum investment of 500,000 baht. But one thing that you need to understand about the board of investment incentive is that it is the investment incentive. So it means that you have to make a new investment into Thailand. So it's help promote the business, that people come invest in the business in Thailand. So having said that, if you already incorporate a company, if you already have a registered capital, if you already invest, so you out of the picture, you cannot apply for the BOI unless you have new investment. So I suggest that before you start a company, you explore the BOI opportunities or which applicable to your business, so that you can maximize the benefits that it's going to give to your company. The benefits include reduction, exemptions of corporate income tax for 5 years, exemptions of the import duties for raw material or machinery. Yeah. Moreover, it gives you the benefits of being foreign majorities owned company without requiring you to apply for the foreign business license, which will take a lot of time. So BOI is I hope that BOI would be a better option for you. Don't having to pay the corporate income tax for 5 years is already good enough. And I hope you make profit before that. Okay. On the next part is the revenue department. I understand that the revenue department has already, trying to promote the business of a startup and SME, but you have to register to be the startup and SME under the regulations, under the relevant regulations. If you register on that, you will have the benefits of having the exemptions for your corporate income tax for the 5 years. But to be able to do that, you have to have a paid up register of not more than 500 million baht. You have to have the revenue of less than 30 million baht per year. And there's another, it's even better than the BOI, because if you are under this program and there's a Thai CVC that is registered under this program investing in your company, the CVC will get the tax exemption for that capital gain and dividend paid from your company. So that's another incentive that CVC might be looking on when investing into your company. So there's other available benefits and incentive, that would help. Say, as a SME or startup, you are exempt. You can do the crowdfunding. You can do the convertible bonds according to the SME and startup law. You can go explore or reach out to us through the True Digital Park one-stop service if you are interested, and we can see what we can help you with. Okay, on the fourth part, this is very Another important thing, corporate structure. It sounds so legal, corporate structure, and it's a vague term and it's a wide term. Corporate structure can be from organization. Maybe some of you may be thinking like, okay, is it an organization chart? Should they have like workflow and the board of director, the CEO, CFO, CMO? But no, what corporate structure that we're talking here today, yeah, that's right, that's also a corporate structure. But the corporate structure that we're trying to tell you today is that I would say it in two aspects. It's how you structure your share capital. It's how you structure your shareholding between the founders and the investor, and it will also be dealing with it when you're doing the fundraising. So under this topic, there's two common questions that I've been asked. When should we set up a company? So I'm asking Gil, what do you think? When should we set up a company?
Generally, I think it depends on a case by case and each person's own decision. But actually, I think the company should be set up when it is ready to make profits and to raise funds from other persons.
Yeah, that's right. It really varies on the occasions, but on my personal view, I think the company should be set up when you're ready to actually raise fund or launch a product. I don't know which state comes first. It depends on the business, but definitely it's not the first thing that you think about. Creating a business is not the first thing that you. Like I said, so tonight if I go to bed and I have a dream and I think of the new brilliant business idea, going to register a company will not be the first thing that I do, because I'm not sure. I'm still not sure whether my company is going to work. The product is gonna work at the idea stage. Maybe you should not register the company just yet. Just any normal founders agreement between the founders. If you have a co-founders, that might be enough at that stage. But let's see. So you really have to think it through and maybe like seek proper legal consult before you enter into any agreement or before you register the company. Because registering the company, it comes with cost. It comes with responsibility that you have to manage that company. Like setting up the company. Setting up the company setting up the company will cost you at least maybe a couple of, no, not even a couple of thousand, but maybe like 10 or 20,000 baht. It's just to set up a company. That's like, yeah. So just think it through before you set up a company. But what I want to emphasize is that the benefits of setting up a company. Gil, what is the benefit for operating the business as a company? Gil, apply any of you. Anyone?
The answer is actually on the screen. So it's a liability, because setting up a company is like kind of creating another entity. So it's like shielding liability from the individual shareholders. So the liability will fall upon the company itself and not the shareholders.
That's correct. That's correct. It's the liability. You don't want liabilities on yourself. So when you're ready, when you are ready to conduct the business, when you're ready to launch the product, you don't want to get sued, like personally sue. So it's better that you have a company to shield your liabilities. The other thing is that tax. So if Gil, what if you, me, and Gil do not set up a company and we get revenue from our business? What would it be? What kind of tax that we have to pay?
So that would be ordinary partnership, and you'll be subject to personal income tax. So subject to the progressive tax rate.
Yeah, so if I make 10 million, if we make 30 million baht for our business, so key employer and I will be each making 10 million baht, so it's 35% tax. I don't want that. I don't want to pay 35% tax. So it's better to be in a company form, and we can deduct expense more than a personal income. We can um, get less tax rate, which is 20%. So that's the beauties of setting up a company. The other aspect that I will go through quickly is that how you structure your shareholding. It's also links to the regulatory requirement. Like in some case, if it says that if the regulation says that you have to have at least like 10 million baht registered capital, but how could you reach 10 million baht registered capital? Um, in many companies that I deal with, so they already raised Series A or Series B, but their their registered capital is still like less than 5 million baht or maybe like 7 million baht, not reaching 10 million baht yet. What happened to that? Because if you imagine like if any of you that have already been through the fundraising, you know that they're not we the investor not coming in at par value. So there is something called premium. Premium is a premium on the share. Is a future value that they're investing in your company. So they come in with premium, and you use this premium as to operate your company. But then they might have just 5% of the shares in the company, but they're investing 100 million baht. So to to structure that, you have to understand the regulatory framework, and then maybe in the case like that, you raise fund at the shareholding. So you have to set up two company. You raise the one company is a holding company, the other one is an operating company. For the operating company, you raise fund at the holding company level, so you raise a premium. So you have 100 million baht from the investor, easy peasy, and then you inject capital in at par value into the operating company that the holding company are holding. That the holding company owns like 100% of the shares in that operating company. So in that case, you will get their full registered capital in the operating company that are operating. But that's a good case for that stage. But but what if the company grow bigger, the company go into IPO? You have to think again, like which company that you are going to get on the stock market. If you want the operating company to go into the stock market, that's easy. But don't forget that an operating company are 100% owned by the holding company. So investor do not get a share. How can the investor get an exit? But if you list at the holding company level, but definitely the SET has a requirement that you have to have a minimum registered capital of whatever $300 million if you're going to list on the stock SET, but MAI is if lower, but definitely not 5 million baht or 7 million baht. So you have to figure out a way on how to convert those premium that being injected into by the investor into something that would meet the requirement of your IPO target. So there is no one answer fits all for the solution. We have to. It's really hard because startup is not a constant picture. You have a different target at each stage, so you have to think carefully on this when you're structuring the company. But I would say that knowing the regulatory framework, if you are operating on a highly regulated business, is a key and is very important. I have seen in some case that the company raise fund, you only have one operating company, you raise fund at the operating company level, but then it turned out that you require 10 million baht registered capital. The way out, one of the way out is that you have to do the entire business transfer and convert the premium into the business and the premium into new company. But that's hard, and that's also a tax leakage. You're transferring properties, you get like 7% leakage of the VAT. that's not what we want to see, but maybe that's the only option that you have to do if you already got it wrong in the first place. Okay, intellectual property, I'll go through it very quick. Sorry, I might have slipped the time, so it will be not more than 5 minutes on this and my 5 minutes on the personal data protection. On the intellectual property, definitely there are like 4 or 5 types of the intellectual property: copyright, patents, trademark, service mark, and trade secret. So what I've heard in some of the foreign podcasts, they say that maybe IP is the only asset or the most important valuable asset that the startup may have. It might be kind of true, but another I might have a disagreement that at some stage the most important assets of startup may be the data. You gain a lot of data and you just have to know how to use it. Okay, intellectual property, copyright, source code and stuff is also copyright. You might not have to register it, but it's already protected. On patent is what you invented. That's straightforward. We are not alternative and partners. We are not the IP expert, but again, tying in the one-stop service for True Digital Park, they also have patent partners that will help you deal with, will consult and help you deal with their intellectual property stuff. What I want to emphasize here in the IP section is about the IP intellectual property that created by employee. That's very important because in startup it's you write software, you write codes, and that involve a lot of tech related IP. So if you do not like I said, the code that you wrote is a copyright. If you're not, and it might not have to be registered, but what if your employee wrote that code? Who has the ownership of that, and what should we do? So basically, one of the things is that you have to specifically write into your employee's agreement, employment agreement with your employee, that whatever product, whatever intellectual property that was produced during the course of this employment as your employee, it should belongs to the company. So that's the basic ground, and that's what you should not miss. Oh, just one more thing. That the difficulties that I've seen on the past deal is that about the trademark or trade service. It's really important for your logos, your trademark, trade name, trade service to it's a valuable assets for the company. In many cases, I've seen that because you already start a company when you do not have it, you already start a business before you having a company. So in many times the trade name, trademark were registered under the founder's name. So before you do the fundraising, you should transfer those trademark trade name into the company, so they add value to your company. Because if the investor conduct due diligence, they will definitely require you to transfer all the trademarks and trade names into the company as well, because they don't want to invest in a company that the goodwill doesn't belong to the company. Okay, personal data protection. The last part is this is very important part. This is very important law. It's new and it's not final yet. We will have to wait until the 1st of June to see like what's law gonna be released. There's a lot of sub regulations that to be understand. But basically, what we have to understand for PDPA is that the usage, the collection, the usage, and the disclosure. So a lot of questions that I've been getting is that whether or not the consent is enough. I would say that only consent would not be enough, because why? Because for consent, it can always be revoked. So what you have to do is you have to first you have to understand what you you have to understand what the purpose of your collection, and what the purpose of your use, and whether or not you're going to be disclosed. The most important thing for the PDPA as of now, with the absence of the sub-regulation, is that you need to have a proper privacy notice. You have to tell your customer what kind of information that you want to keep, we want to collect, and how you're going to use it. For example, if I'm a delivery, a food delivery apps, do you need my ID card to register? I would say no. Why would you want my personal information? Like, there's a lot of personal information in the identification, my ID card, like my ID number, my name, my full name, my date of birth, my address. You only need my name, my telephone number, or my address, just to know that how you can deliver to me. Or if you are stock trading app, definitely you will be required to do the KYC. But if I'm sure like many of you have already tried the eKYC. So basically what you have to do is that you have to take a selfie of yourself and your name card. I'm sorry, not name card, ID card. You take this, and then they will verify you. But as an operators of the app, I would definitely ask, do you need my know what religious I believe? Do you need to know that in order for you to verify who I am? I would say no. So that's why you have to try to minimize. You minimize the data that you collect, and do not collect unnecessary data, because the customer will always come back, and can always come back and ask you to delete those data, and it would be hard if you already collect them. So what we've been advising our clients is that they have to redact. When you do the form, you have to you take the picture, you have the form, that you redact the unnecessary part of the document, of the personal data. Okay, I think that's would be the end of our slide. I'm not sure if I have 5 minutes of the time to address the question. I've seen the questions. Okay, let me try to. Yo, can you read some questions to me?
The first question is the best practice to license intellectual property right from offshore company to Thai company.
Which one? Which one is that?
That would be the second one in the table.
Oh,
Yeah.
okay.
The one that's previously sent before.
Okay, so setting that aside, we are not we are not expert on IP, but basically you should have a written licensing agreement to do the licensing, and that's the key. And those licensing agreements need to be registered at the DIP, Department of Intellectual Property. Okay, I'll read through one of the questions. Well, Kun Porsche Git, what agreement should you to know? I'm not sure, but about what kind of agreement. But I would say that, like I already emphasized, the founders agreement is really important. And if you go back to see the slide and our talk during that topic, it will be you should cover those important topics in your founders agreement. What's the difference between founder agreement and article of incorporation? Okay, article of incorporation is just the document that you applied and register to the Ministry of Commerce. But if you mentioned it about if it's an articles of association, which is the common cup of the company, Kun Grit Susa Aman, that's a different part. The articles of associations, there are certain details that it's just contractual between the founders in the founders agreement, and So basically founders agreement is a contractual between you and the founder. So it will be only applicable to, it will be enforceable just only between you and the other founders. But articles of association is also applies to the company. So there might be in some elements like for example, share transfer restriction that can be both in the articles of association and in the founders agreement. How can you account operating expense before and revenue generation without incorporating the company? So basically, it will be like I said before incorporating the company, you will be operating as a if you are alone as individual, but if you are together with your partner, this will be a partnership. Okay. So I have one very interesting questions, and it's a very common questions that I've been asked whether or not we should register the company overseas or is it better in Thailand? Again, I hate to say this, but I think I have to say I have to tell that it's really up. It really depends on the circumstance and how your company how your company is operating. So I have heard a lot of startups saying that okay, it's true. It's kind of true that as of now, while Thai government is trying to change a lot to be more friendly to the startup. If you want to raise, a lot of people are saying that if you want to raise fund from the international or foreign CVC, it's better do it in Singapore or elsewhere. But don't forget this: if you are operating the company, if your whole operation is in Thailand, so you have to think about how you register the company, you raise fund in Singapore, but then all the whole operation is in Thailand on hand. And you remember there's in the on the regulatory framework session that I mentioned about the foreign
investment.
Foreign direct investment. If your Singapore company holds 100% in your operating coal in Thailand, you will be subject to foreign direct investment. So it might prohibit you from doing a business in Thailand, but it's that again that depends on the business that you're doing. So yeah. I think that would probably be all. Okay. Sorry for some inconvenience that I was locked out for a while, but thank you very much that you've been for all of you that participated in the session. Thank you very much, Kyo and Ploy, for being with me today. Thank you again to Digital Park for this wonderful session and the opportunity to giving us alternative and partners to be part of this. Thank you. Have a good night, everyone. Bye bye. สวัสดีค่ะ